This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we talk about why a genuine dispute will require reversal of a trial court's summary judgment and why property damage invokes an insurer's duty to indemnify, even after finding that there was a defective construction of a silo on a farm. The Fifth Circuit was asked to determine if, quote, property damage, close quote, existed that would invoke an insurer's obligation to indemnify under a common commercial general liability insurance policy. The district court determined there was no property damage under the policy, and the insurer therefore had no duty to indemnify the insured for an adverse state arbitration award. In TIG Insurance Company versus Woodsboro Farmers Cooperative, the United States Court of Appeal for the Fifth Circuit on September 20, 2024, determined that there was, in fact, property damage. In March of 2013, Woodsboro contracted with E.F. Irwin, Inc. to construct two Brock 105 diameter grain silos in Woodsboro, Texas. Irwin hired subcontractor AJ Constructors, AJC, to construct the silos, and Irwin was responsible for supervising their work. Brook silos start as kits shipped from the manufacturer and are then assembled according to the manufacturer's manuals and specifications. In short, constructing a silo is a matter of assembly. It requires putting the pieces together pursuant to the manufacturer's instructions. AJC began erecting the silos in May of 2013 and completed the work in June or early July. According to Woodsboro, at the time, Irwin represented that the silos were ready to be used as intended. However, several defects were discovered that caused the silos to leak. Irwin attempted to repair the defects but was unable to make them watertight. Woodsboro then contacted Buck Pitcock of Pitcock Supply, Inc. to inspect the silos, and he observed numerous faults with the silo's assembly. Pitcock attributed the damage to AJC's poor workmanship. Woodsboro hired Pitcock Supply to repair the silos, and when Pitcock Supply finished its work in June, Woodsboro's total cost was $805,642.74. In August of 2014, Woodsboro sued Irwin in Texas State Court for breach of contract, and the case was sent to an arbitration panel. The panel found AJC had negligently constructed the silos were defective and did not conform to the construction contract and subcontract, and Irwin was unwilling or unable to repair them. The panel awarded Woodstock a total of $988,073.25 in damages. TIG Insurance Company sued Woodsboro and Irwin and sought declaratory relief on its duty to defend and indemnify as Irwin's insurer. The court granted TIG's motion as to its duty to defend, finding the underlying pleadings failed to show that Irwin's breaches resulted in property damage required for coverage under the policy, and even as such damage existed, several exclusions would apply. The district court granted the remainder of TIG's motion for summary judgment, and the court concluded that there was no physical injury to tangible property because Irwin's breach, apart from defective construction, nor was there any loss of use of the silos because the arbitration panel found that Woodsboro had lost profits on account of Irwin's late delivery of the project. The court, analyzing the issues, noted that the duty to defend is governed by the Eight Corners Rule in Texas, and that is determined solely by the facts alleged in the petition and the terms of the policy. The duty to indemnify, on the other hand, is determined by the actual facts establishing liability in the underlying suit and therefore generally cannot be ascertained until the completion of litigation. Once Woodsboro filed a petition for breach of contract, there existed a potential claim for coverage sufficient to constitute a case or controversy and confer standing on TAIG as Irwin's insurer, and the Fifth Circuit, however, concluded that the district court did not err in deferring resolution of indemnity issues until the liability litigation was resolved and a final judgment was entered. TIG may have a duty to indemnify. Irwin holds a standard commercial general liability insurance policy, and under Texas law, physical injury to tangible property requires tangible, manifest harm and does not result from merely upon the installation of a defective component in a product or system. The district court determined Irwin's role was more akin to defective installation requiring repair than defective work which caused physical damage to other property. Based on testimony and evidence, the panel found the silo bins as originally constructed by AJC were defective. Although the district court's interpretation might be reasonable on the face of the arbitration decision, it failed to make all inferences in Woodsboro's favor as the non-moving party. Pitcock observed degradation to the rest of the structure. The record reveals at least some evidence of wind and weather damage during the policy period. Satisfied that the evidence, when viewed in the light most favorable to Woodsboro, supports the determination that property damage occurred, the Fifth Circuit then looked at the exclusions and concluded that there was evidence suggesting that sometime between AJC's exit from the project and Pitcock's assessment in May of 2014, wind and weather damaged the silos. Thus, damage from the wind and weather could have occurred after AJC's active performance of work. The Fifth Circuit concluded that a genuine dispute of material facts existed, making the district court's grant of summary judgment improper. Physical injury can be inferred from the arbitration panel's findings and the evidence, but that is inappropriate at this stage, so the district court's judgment was reversed. In my opinion, property damage was seen to have occurred after all work was done on the silos before they were replaced. Since wind may have caused damage to the defectively built silos, there was evidence of property damage as required under ACGL, and there therefore existed a potential for coverage to indemnify the insured who improperly and defectively constructed the silos. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5 or 6 a week. And you'll also receive access to the more than 4,850 blog postings. You can also subscribe to these videos on rumble.com and youtube.com. And if you do, I'd appreciate it if you click on the like button on YouTube and the thumbs up button on rumble.com. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider for a very small fee subscribing to my Substack publication. Thank you for your attention.